Commissioner resumes. Mr. Bam.
Thank you, Commissioners. The next topic that I want to go on to is dealt with in our replying heads at page 856, and that's the shooting of 10 August 2012. Page 856, the topic commences at paragraph 33 and is dealt with until paragraph 36. The reason we deal with the topic is because what is said by the evidence leaders in relation to that incident. Now, you'll recall the incident very briefly. It's an incident Mr. Botha had spoken to, when on the evening of the 10th of August, they discharged their firearms with rubber bullets and tear gas in order to disperse a group of people who they said were intimidating people who were on their way to work. The evidence leaders say the following at paragraph 1217 of their heads of argument. They say the shootings that occurred on the evening of the 10th by Lonman security personnel, which are addressed elsewhere in these submissions, were not adequately explained by Lonman. We submit that Lonman had failed to place any facts before this commission, except for the bland allegations that the strikers were intimidating workers, to show that the shooting incidents on the evening of 10 August were justified. They then say, on this basis, and in light of Major Governor's evidence that in his view there was no basis for SABC to act against the strikers, we submit the Commission should make findings that the shootings were unjustified. There are two aspects to that criticism. The first is that it is stated that Lonman simply put up bland evidence, and the second is that look at what Major Governor had said about the conduct of the strikers. We would submit to you, Commissioners, that the evidence leaders are incorrect in both regards. In the first instance, you've heard evidence about the atmosphere of intimidation which had prevailed at that point in time. In fact, there's an oddity about what the evidence leaders say in this regard, because elsewhere in their heads they make much about the context of Impala. They say that Lonman ought to have been alerted to how things could develop because of what happened in Impala. They say to you in relation to Lonman's, what they say was a state of unpreparedness from a security perspective, that Lonman ought to have been ready because of what happened at Impala. And yet when a witness comes and says that which occurred at Impala also characterized the events of the 10th of August, they say to you that's a bland statement. Now, you can't have it both ways. It's one way or the other. But
why were the entries about that incident removed from the occurrence book? And why did Mr. Botha, in his evidence, transfer them to the 11th?
Sorry, I missed the second part of the question.
I think it was Mr. Botha in his statement said that described those events, but put them on the 11th. And there was a fair amount of circumstantial evidence in the statement which made it appear that it was indeed the 11th when these things happened. And then later, very late stage, files an affidavit say, oh dear, he's made a mistake. These things happened on the 10th. There's no explanation really as to how he made that mistake. When you read that, together with two other facts, one, the one I've mentioned, namely the omissions from the occurrence book, and secondly, the fact that Mr. Sinclair, who was also present to some extent on the 10th, doesn't mention it at all in his statement. So, why do we have those facts?
You're absolutely right in relation to raising the questions on the deletion in the occurrence book and what Mr. Sinclair has said. Let me state it clearly now, because there is criticism about that. Mr. Sinclair was responsible for deleting items from the occurrence book, wrongly, incorrectly, and I'm not going to defend that. He was just wrong in doing that. We found that out at a very late stage. He's no longer working at Lonman. I can say that now. And he's no longer working at Lonman because of what emerged regarding the tampering of evidence.
What inference does one draw from the fact that the deletion took place? Sorry, you're going to get to that. Sorry.
I'm dealing with it sequentially.
Forgive me. Please argue the way you want to.
Yeah. I'm terribly sorry. I mean to come there. Now, if all that you had before you was an incident which occurred on the 10th, which was recorded in the occurrence book, which was then deliberately deleted, and you can only come to that conclusion in relation to Mr. Sinclair, then I might have been sitting here wondering how I deal with that. But that's not the only evidence you have before you. So the first question is, was there a shooting on the 10th? The answer to that is yes. The second question is, on the facts before you, can you simply dismiss what Mr. Botha had to say about acts of intimidation The answer to that is no. We know there was a background of Impala, we know what happened there, and you're being urged in relation to that background to have regard to the nature of violence which occurred at that strike. Now, if that had happened at Impala and you're being asked to take into account that background, why is it improbable that there was a similar occurrence of intimidation on the night? The third aspect is, yes, Mr. Botha did say he erred. But what you do know is that on the day, there were incidents of unrest and intimidation. How do you know that? Quite independently of what Mr. Botha has said, you've got to look at the cross-examination of Major Governor, an aspect which has been left out in the manner in which the evidence leaders have assessed Major Governor. Let's do that, because you'll find that three critical aspects come from his evidence. The first is that he stated and he spoke to...
Paragraph 35 of your...
Yes, but if you look at the transcript on the 14th of August, page 35090, there are 3 points I'm going to make about this. The first is he spoke to an email he received on that evening from the police reporting on events which occurred on that evening. Now, this is quite independent of anything which Sinclair did and which Botha spoke to. So it's an outside source talking about what occurred on the day. And that email, which came from within police sources, said to Mr. employees suspected to be AMCO members. Now, let's leave aside the suspicion of where they came from, because that's just a question of suspicion. What is stated as a fact is that an incident of assault had taken place, intimidation. The second is that he was then asked to confirm that on that evening there was a group of people armed with knobkieries who were standing on the very path that people would pass to go to work. He said yes, they were standing with knobkieries. He was asked why would they have been present. He said he asked them and they said they're waiting for a taxi. Well, they disappeared shortly after that, and this was an exchange between yourself, Mr. Chairman, and him, when you said to him, well, did it not strike him as strange that people who said they were waiting for a taxi disappeared before the taxi had come, waiting incidentally with knobkieries, as it so happens, on a path where people who wish to go to work would have to pass. That's the second aspect. The third aspect relating to why he did not agree with Botha on taking action to disperse with them. He admitted eventually that he did not have any training to manage a crowd or crowd control. In other words, assessing the situation was beyond the ambit of his training. So what do you have from that? You have from that, yes, the completely unsatisfactory and unjustifiable conduct on the part of Sinclair regarding the deletion from the occurrence book. There's no question about that. But does that mean the incident didn't occur? And does that mean the discharge of the firearm was unjustified? It cannot mean that, because you've got independent evidence of a report of unrest on the day where workers who were coming away from work were assaulted. You've got the confirmation by Major Governor of a group of people who were standing in a very strange place, we might say on the Friday evening, armed with knobkieries, one might ask why, and giving an explanation which didn't make sense. And you've got Major Governor's final concession that his training did not permit him to assess the situation at that point in time. So we would submit to you, Commissioners, that you simply cannot disregard what Botha says about the fact of the occurrence and why the firearm was discharged, and that what he says is supported by what Major Governor had conceded during his cross-examination. Cross-examination which is entirely omitted in reference in the assessment by the evidence leaders of the situation.
Mr. Baum, what do you make of the fact that Major Governor didn't see that the crowd or the group of people in possession of any sharp weapons?
No, he did not. You're absolutely right, but he did see them in the possession of knobkieries, firstly. Secondly, he saw them standing at a place you would not expect people to be standing at the time of the evening.
What do you make of the fact that while he was there, they didn't do anything that he thought was actionable?
He says he did not believe the situation was intimidating. He was told that they were there to intimidate people who were going to work. We do know that it was reported to him that people were assaulted on that evening. The simple point of the matter is that, do you wait until people are beaten up before you try to disperse the crowd of people who want to beat others up? Or do you assess the situation in order to try to prevent the occurrence? And Commissioner Hemorrhage, in many senses, what we faced with when my learned friend Mr. Berger had referred to the schizophrenic criticism of Lonman is we're damned if we do and we're damned if we don't. If they had done nothing and that very group of people had assaulted people going to work, we would have been criticized for not having prevented that. Because we urged a measure to prevent the assault of other people, having assessed the situation, which by all accounts objectively would appear to be an unusual situation where a group of people are standing for a purpose they couldn't explain. And you acted in order to prevent people who wish to go to work or who are coming away from work from being assaulted. You criticized for that.
What inference do you draw from the deletion of the entries and the fact that Botha transfers this to the following night? If you apply the balance of probability standard, would it be, I'm not asking this as a rhetorical question, I'm just asking for information. Would it be appropriate to draw an inference that what Sinclair was trying to hide was there'd been an excessive reaction, over vigorous reaction by Lonman in dealing with the situation?
Let's make the first point what Sinclair, it wasn't the only entry he deleted. On every occasion when firearms were discharged, he deleted that. Now, his motivation behind that appeared to be to delete all those references. So not to justify whether it was an overreaction or underreaction, the mere fact that there was a reaction, he sought to delete. And as I said, you simply cannot condone him for doing that. We have not sought to do so, and we say you can't do that. But against that, before you draw any inferences, when you draw inferences on the totality of the facts. Among the totality of the facts is that there were medical reports which showed that people had been assaulted on the 10th. Injured and assaulted on the 10th. That was part of the evidence. The shooting reports that we made available well before the time Botha and Sinclair came into the witness box had made reference to the incident as having occurred on the 10th. The email to Captain Govender, which referred to people having been assaulted on the 10th, is another factor. The fact that there were people standing around in unusual circumstances who gave a false answer is another factual incident. So the point I'm making is, if the only fact before the commission was that on that day an incident had occurred and Sinclair went and deleted the item, well, then on that fact, because that's all before the commission, you would have drawn an inference as you suggest. But that's not the only fact. In other words, you're now seeking to draw an inference based on a particular fact of an individual whose deletion and whose activity in deleting items was not restricted to that particular issue.
I'm not seeking to draw any inference, I'm just asking what inferences can be drawn. And it may be that there are two inferences you draw. The first inference is the strikers were behaving inappropriately, intimidating people who want to go to work. And the second inference you may draw is that the response of London to that situation was excessive, which is why Botha's moved it to the Saturday night, and Sinclair removed that entry together with others. But I'm not saying one must draw inference. I'm not seeking to draw any inference. I'm just asking for assistance and what inferences, if any, can be drawn.
I'll try to do that. In relation to the inference you mentioned, the second of the two inferences, which is whether it was excessive conduct or not, there are a number of points to make. First of all, you've heard no testimony from anybody who's come to say that the extent of the shooting was excessive in relation to what we had done. Second is you've not heard any evidence of people who had sustained any injuries of a nature as a result of that conduct which would suggest excessive injuries or rather excessive conduct on the part of Lonman. And the third thing, and we go back to that, is all of the objective evidence points to the fact that there were a group of people with intent at that point in time, and that intent was not a pleasant intent towards people who either were wanting to go to work or who had come from work. Now, if, as you were told by Botha, he made a mistake and he admitted that mistake, the firearm register did not make the same mistake. It made exactly the full disclosure, and that had been made available. Ultimately, you've got to be careful in drawing inferences in being colored by one fact, and unpalatable from our perspective and unacceptable fact of the deletion from the occurrence book. There's no doubt about it. As I said to you already, that if you had that and nothing else, then I might have had a difficulty in arguing the point. But we're not sitting with only that. And the reason why you can't draw any inference of excessive use of force is because there is no evidence from you, either in the form of anybody who was there at the time who said it was excessive, or of any reports of injury of a sort being sustained, which would suggest excessive use of force. So you simply don't have that evidence before you.
There is a docket with 2 persons alleging to have been shot on that night, but whether there's a sufficient nexus between that shooting and Botha's is not very clear to me.
That's the first point.
These aren't people who allege that they were attacked by intimidating strikers.
No, we may be at cross purposes. Those would have been in relation to people who were shot at on the day.
Yes.
Now, there are a couple of things. First of all, they don't draw the nexus between that incident, as you say. And secondly, there was no evidence led at this commission about the nature of their injuries and the extent of the shooting, which would suggest that you can draw an inference of the excessive use of force. In other words, we're sitting now with a commission which is set for just on 2 years, with extensive evidence having been led, with time having been given for evidence to be led, in order to allow us to draw inferences from facts put before the commission. To draw inferences from facts which are not before the commission is to draw inferences from speculation, when you've got the facts. And so consequently, in relation to that incident, I would submit to you that not only is there insufficient evidence to draw an adverse inference against the incident of shooting on the day. Of course, you can comment about, and you should, about the deletion from the occurrence book, because it is just unacceptable. But what you can't do is translate that into an inference to be drawn against the incident having occurred and the justification for the incident, nor is there sufficient for you to draw an inference about any excessive force. May I then go on to the next topic, and this is dealt with in our replying heads at 858. The characterization, and I'm going to be fairly
Sorry,
brief
858 you say?
on the point.
Yeah.
And 858 of our heads, our replying heads, starting at paragraph 39. And we make the submissions primarily because of the persistent attack against Lonman, particularly on behalf of the injured and arrested and the families. And the criticism is that Lonman ought not to have characterized the strike as acts of criminality. The criticism, though, conflates 2 separate issues. And those 2 issues are the advancement of a demand for a particular amount, which is a matter to be dealt with between employer and employee. And the second is the manner in which the parties advancing the demand had conducted themselves. Now, I don't want to suggest for one moment that every single person carried out acts which were outside of the framework of the law. But the reality of the matter is that the manner in which events had unfolded. Forget the demand for the timing. You now talk about the manner in which the demand is unfolded. So let's move away from the strike. A very simple, trite proposition of human nature I would put to you. That if I ask you for something legitimate, but I come and punch you on the nose in order to try to get it, you may examine the legitimacy of my request on the one hand, but you're going to take very unkindly to that bleeding nose on the other hand. Now, I put a simple example, and I don't put it facetiously. The simple point is that when the events were characterized as criminal, they were characterized as criminal because of unfolding events and the conduct in that process. By that stage, Mr. Fundi and Mr. Mabelani were killed. We've seen photographic evidence of their bodies. It was gruesome. It was brutal. By that stage, Mr. Mbebe and Mr. Langa were killed. Questions still remain about precisely who had killed them, but it seems to be generally accepted that they were killed from people who were amongst the group of strikers. In other words, there was conduct from people amongst the group of strikers which had moved from a legitimate manner to advance a demand to an unlawful and criminal manner in advancing the demand. That doesn't make the demand criminal. It makes the manner in which it is being done criminal.
Of course, the possession by a significant number of strikers of dangerous weapons, which
Well, there's
in
more
itself,
than that.
in itself is an offence.
Yeah.
And they were engaging in public gatherings, armed with these dangerous weapons. That in itself was an offence, wasn't it? So it's not correct to say that this unprotected strike was not accompanied by criminality.
It goes beyond that because you've now got evidence from Mr. Nsuza, who was the second in command, and you'll recall my exchange with him in cross-examination. In your bundle of attached to our heads, it's at page 394, where on his behalf and through him, he was quick to say that those who were responsible for the deaths of Mr. Fundi, Mr. Mabelani, Mr. Mbebe, and Mr. Langa, and Mr. Twala should be criminally charged. And then when I tried to cross-examine him on that, we got involved in a long debate with my learned friend, Mr. Mpofu, on whether they'll be convicted and not, and the like. But the simple truth of the matter is, Mr. Nsuza could only have said that if anybody is found responsible for those deaths, they ought to be criminally charged on the basis of his own appreciation that whoever was responsible in that conduct acted incorrectly, and that conduct was conduct of a criminal nature. Now, once that comes from him, to suggest that it was wrong for Mr. Jamison and thereafter the Vice President, Mr. Ramaphosa, to characterize that conduct as criminal is just amazing, frankly. The manner in which certain people had conducted themselves, the hard evidence of what had happened from the 10th onwards, you simply cannot characterize that conduct and its outcome in any other manner. At the very least, it's a fair characterization and doesn't justify the criticism of that characterization. The next issue that I would like to deal with is at page 859 of our heads of argument, and that goes to the capacity of Lonman security. Now, in this regard, there were a number of matters which were dealt with, in respect of which Lonman security was criticized, and the essence of the criticism was that you were inadequately equipped to deal with the events which unfolded, and consequently inadequately equipped to deal with injuries to persons who were injured in that period. When I say persons who were injured, I'm talking of between the 9th and the 13th, when Mr. Mabelani, Mr. Fundi, Mr. Langa, and Mr. Mbebe were killed. And all of that is because you failed in a broader duty you might have had. That entire debate, in the first instance, overlooked evidence given by Mr. Blow, which wasn't challenged. And that evidence was that in 2005, a process had commenced for Lonman to demilitarize its operations. In other words, to move from dealing with events on this scale to dealing with crime and the like on a lower level. So if the question is asked, was Lonman equipped to deal with the events as they unfolded, the answer is obviously not. They weren't. But the question cannot stop there. Lonman, and the question that should be asked is, ought Lonman to have been in a position from a security perspective to deal with these events? Could it have been expected of Lonman, and can it be expected going forward of companies to have a sufficiently sophisticated and extensive security network, including armed guards all over the show in extensive numbers, to deal with the events as they unfolded? And we would submit to you that cannot be expected of them. It's a wide area, it's a significantly extensive event, and it is precisely why you have the South African Police Services with a constitutional mandate to deal with events on this scale and of this nature.
Mr. Nkatobi referred to a judgment which I was responsible for in a matter in which Mr. Berger appeared in the SCA, dealing with the obligation of an employer to provide a safe area for his employees to work in, which obviously involves obligations to provide some kind of protection. Now, the main criticism on this part of the case relates to the refusal of the board of London to accede to motivated requests, I would have thought well-motivated requests, by their own security staff to give them extra equipment which would enable them to protect the workers, and in particular to protect the security guards. I don't know that the argument goes so far as to suggest that London should have turned their mining premises into an armed camp. The main thrust of the criticism is their own security people foresaw the need to have armoured vehicles and certain other equipment to protect the security staff who would be performing the functions of protecting the ordinary staff. And that was turned down. And the impression gained is that the board preferred to expose their security people to the risk of being killed or seriously injured rather than to depart from, even to the extent requested, depart from the policy of demilitarization, which had been adopted, I think, in a slightly different security environment in 2005. I'm not saying that's a good argument, but I'm just putting to my understanding of the case that you have to answer on this point.
I'm quite fortunate that that one of the persons involved in that SCA case is sitting next to me, and he's just told me that the SCA case was directed towards protection of workers against acts of sexual harassment. But let's assume it goes slightly wider.
But the principle, that's quite correct.
I want to deal with the principle now.
Recollection is absolutely correct. But the principle laid down in that case, not laid down as a new principle, by the way, but based on earlier authority, was that an employer has a duty towards his employees to provide them with a safe working environment. Now, obviously, one can't impose absolute liability on an employer in respect of that obligation. The most one can expect is reasonableness. But the point argued, whether it's a good point or a bad point, we'll have to decide at the end of the day. But the argument put up on behalf of the LRC was that it was reasonable for, and also the evidence leaders too, was reasonable for London to comply, at least to the extent of providing armoured vehicle and other equipment. The answer to in respect to the armed vehicle was, well, we've got the contractors who are some distance away, and if there's a need to get an armed vehicle, we can phone them and they will send the vehicle. Of course, how soon the vehicle would have arrived, what would have happened before the vehicle got there, are matters that are left to one's imagination.
Can I deal with both of those aspects? In relation to the first one, the principle that it's a duty of the employer to protect a safe working environment, one would hope that every employer does so, whether it's in a small household context or it's a larger factory context. But you've got to ask yourself what the limits of that protection are. Let's take it at its lowest. I'm an employer in a household context. I've got staff working for me. The best I can do is to employ arm reaction, perhaps a security guard on the street and the like. Am I expected to do more than that? If my home is then invaded by 5 or 6 armed people, and in that context there's inadequate security, have I failed in my duty? How far am I meant to go in the provision of that? On the facts of this case, it is one thing to state a bland statement of an employer's obligation. It is quite another thing to apply that statement to what occurred in this instance, because then you would have to say that in this instance there was an obligation on Lonman to have sufficient security to have protected everybody in its premises, some 38 square meters, against the type of incidents and in the circumstances which prevailed at this point in time.
But that's not the point that you have to answer. The point you have to answer deals with the failure to provide adequate equipment, adequately protected vehicle for the security staff, not the whole staff, the security staff who would have to go and deal with violence and disorder and so forth. And it's a refusal of a request by Lonman's own security staff who say, I think Mr. Sinclair, Mr. Boyters, I think it was, who's addressed, I think on more than one occasion, specific, well-motivated request to the board for the expenditure that was required to provide the equipment that they suggested was necessary to deal with not remote possibilities but foreseeable contingencies about which they were concerned. That's the case you've got to answer.
Sorry, Mr. Chairman, you asked me, you put two propositions or two issues to me. I dealt with the first one, and I was getting on to the second one, as you just repeated. So I now want to get on to the second one. In other words, the first proposition you put to me was the wider proposition of providing security at the workplace, and I dealt with that. In response to my answer on that, you put the second proposition to me, which I'm now getting to, which was the second of two propositions you had put to me. And that is the question is simply framed as that. At the very minimum, was Lonman required to provide the additional equipment for its security personnel, which they had asked for repeatedly, and you heard Mr. Blow and a number of other people say, which included hard-skin vehicles, as it was referred to here. There are a number of aspects to that. The first aspect to that is in relation to what occurred here, because you've got to ask yourself, firstly, the criticism arises from the deaths of Messrs. Fundi and Mabulani. Tragic circumstances. So that criticism and that issue can't go to the deaths of Mr. Mbebe and Mr. Langa. It goes to Mr. And now you've got to ask yourself what the evidence was before you in that regard. Let's start off with your question, but I want to go beyond that to look at the evidence as well, because we can't ignore the evidence in this regard. In the first instance, yes, it is true that the Lonman security personnel had asked for better equipment, more sophisticated equipment, and even hard-skin vehicles. It is also true that Lonman made a business decision and did not provide that. But in relation to the deaths of Messrs. Fundi and Mabulani, you've got to ask yourself the question, because that question only arises as a result of their deaths, their tragic deaths, and in the attempt to suggest that if Lonman had done something differently in that regard, a different result might have eventuated. Now, there are a couple of aspects to that. You can't ignore the evidence of the very security people who spoke to the need for more security equipment, who said that they had never previously experienced a situation where if they stood in front of oncoming workers who were on strike and asked them to disperse, they were met with a violent reaction. The second aspect that they spoke to was that they never expected at all that they would be attacked. They said previously if they discharged rubber bullets or the like, even though there might have been a small number of them, it would have resulted in people having dispersed. They said that. So the evidence was that as well. And the third thing, and it is in part disregarded by the evidence leaders, but significantly, what was stated by Mr. Msibi, that he said when they got there, they were asked by Mr. Mabulani to form a line. He said he thought that unwise. He was concerned about whether it ought to have occurred. They picked up the danger signals sufficiently early to have gotten away. Tragically, Mr. Fundi and Mr. Mabulani were caught in their car at that point in time. Now, the formation in a line, would that have been different if there was a hard-skin vehicle? The second point is, you criticize what they had done in the operational decision they took on the 12th. At the same time, we've heard criticism about their conduct on the 11th when there was the march on NUM. In other words, they did nothing other than go and alert NUM. In fact, during the cross-examination of one of our witnesses, the question was raised, well, why don't you try to do anything more to stop these marches from going to the NUM offices where all the records and the like were kept? The difficult truth, and it is a difficult truth because two Lonman employees were tragically killed on the day, is that there are instances in which members of security forces in situations of this sort are at risk precisely because of what they're confronting. They're the first line of that defense. Yes, it would have been very good for the security staff, and they still want it. They've been asking for it time and again, to have had better equipment and hard-skin vehicles. Would that, on the facts of this case, at that point in time, have yielded a different result? You can't come to that conclusion. So in other words, you can criticize Lonman for not having had hard-skin vehicles. You've got to ask yourself, how many hard-skin vehicles? Used by whom? Do you need it in addition to what you've contracted for with Coin Security? All of those questions remain unanswered in the bland statement that if they had nyalas and if they had different type of clothing, there would have been a different result. Regrettably, in this instance, that criticism serves only to do one thing, and that is to shift focus from the true cause of the deaths of Mr. Mabulani and Mr. Fundi. And that is the violent conduct on the part of certain people who they tried to stop, who they called out to stop, and who attacked them and left them in the state we saw. We were subjected to these photographs. That was the intent with which they were killed. Now, if you just look at the outcome of the manner in which they were killed, you've got to ask yourself whether if they had been better protected with the intent that was shown on the date, a different result would have eventuated. The state of their bodies, regrettably, doesn't give you the result that justifies the criticism.
Bam, what do you say about what happened at K4 Shaft, where there was just one security person, where there was knowledge that the strikers might be marching in that area? There had been recent incidents of intimidation and violence, and there's just one person.
You asked the question quite correctly, and again it goes now back to the first part of my answer. Remember, there were two propositions. So the second proposition was on equipment. The proposition you now put to me and the example you put to me goes to the extent to which protection can be offered. Now, first of all, that shaft was at a distance from where the events had occurred. It is true, and in fact we saw from Mr. Nsouza's evidence when he tried to downplay the reason for them marching towards the shaft on that day. It is true that there was the possibility of elements from amongst the strikers heading towards other shafts. The question that you've got to ask yourself is, given that the Lonman security staff was in total 60 people, and given where the focal point of the problem was at that point, which had already completely stretched that limited resource, what more could have been done at that point in time? Now, you could ex post facto say they should have employed more security guards, they should have had more contractors and the like. But the reality of the matter is, Commissioner Hemraj, they were not equipped to deal with an outbreak of violence and attacks at that level. Over the whole mine, which is extensive. In other words, you asked the question about K3 shaft. K4, my apologies, about K4 shaft. At that point in time, you probably have found a similar limited security presence at a number of other operational areas which were away from where the copy was in the central focal point. If you were to suggest that they ought to have beefed up security at K4 shaft, first question is to what extent, what would have prevented it? And it could not have been limited to K4 shaft. It would have been across the operational areas. And now you begin to get again into the debate of how extensive a security force ought they to have provided at that point in time. Is the obligation on them to provide security to deal with events which is beyond the ambit of what they're capable of dealing with? Or does it at some stage cross the line between what they're capable of and the responsibility of the South African Police Services? So you can't look at the incident at K4 in isolation, because you would then have to find, most unfortunate that it happened at K4, but K4 wasn't the only one which was so thinly staffed. But is so thinly staffed a criticism? You can only make that criticism if you're going to find that they ought not to have demilitarized. It gets back to that entire debate. There ought to have been a lot more security capable of dealing with incidents all over the show in what geographically is an extensive area, when the resources, limited as they were, that they had, were employed to deal with the focal point of where the problem area had lied. So again, what I'm submitting to you is that the criticism and any adverse finding against Lonman in relation to K4 would overlook the fact that occurred at K4 but could as easily have occurred at one or other of the operational areas. And to say that you had to focus only on K4 would be to predict it was going to happen at K4, when you knew it might happen at other areas. But what was the extent of your resources to protect each of those areas? The final aspect I want to deal with is dealt with by reference to an extensive quote in our replying submissions.
Just before you move on, the ICAM report identifies other areas that Lonmin itself admits that they fell short, not related to capacity. What do you say about that?
No, there are two aspects. Remember, when they talk of having fallen short, not relating to capacity, they're talking of having fallen short in a number of respects which have not been raised as being related to the cause of any of the deaths. In other words, what I'm dealing with is where the death did occur, because those are the facts and that's the ambit of the investigation. In this instance, the death at K4. And the issue in relation to K4 was the limited security personnel. In other words, those aspects you referred to, Commissioner Hamraj, which the ICAM report referred to as having been inadequate, are not aspects which in any way arise in the debate about the number of people who were at K4 at the time.
Yes, but moving away from K4, the other criticisms that arise in the ICAM report, what do you say about those? I'd be obliged if you deal with them.
I don't make any submissions beyond what we've already stated. For this reason, Commissioner Hamraj, your mandate goes to the deaths of people, injury to persons, and the destruction to property. Now, absent any aspect being linked to the items or the matters you are investigating, I haven't considered that. We haven't dealt with that because it simply is outside of your mandate. In other words, you may, in your operations generally, have numerous shortcomings on numerous matters, but we're not investigating all of that. Which would include insecurity. What we're investigating is such shortcomings as may have contributed to the deaths to persons and injuries to persons and damage to property, which forms the subject matter of this Commission's mandate. That's what we focused our evidence on. That's what we focused our investigation and inquiry on.
Yes, that is as I understand it. And there are instances in the ICAM report which do deal with breaches of protocol and security that do lead to whether the employees were properly protected.
Again, sorry, I don't mean to turn the debate around. In relation to the specific deaths of persons and injuries to persons, I'm not aware of any aspect of that ICAM report which becomes relevant in respect of the deaths that we're looking at. And that's why I don't make a submission on that. And if I'm wrong on that, Commissioner Hamraj, perhaps I'll be pointed to a specific instance, but I'm not aware. And that's why we've tried to focus. A lot has been said in this commission. There's been a lot of evidence. There's been a lot of references in many exhibits that have been put up. We've tried to focus on what the terms of reference of this commission are in order to assist the commission in what it's got to deal with. And that's why I'm not aware, and if there's something specific, perhaps it will be drawn to my attention, but I'm not aware of the causal link between any of those other shortcomings and the matters being investigated by the commission. So may I go to the last issue that I'm going to deal with, and that's dealt with at page 861 of our heads of argument, our replying heads of argument, paragraph 49 onwards, and this deals with the failure to close the mine. There's a subtle, nuanced additional issue, and that is a criticism about having positively called on people to go to work. Let's deal with the first issue, and that's the failure to close the mine. Now, we've quoted extensively in paragraph 50 of our heads of argument the passage from Mr. Sirat's evidence, which was not challenged. And that was, first of all, the time period within which the mine could have been closed. It would have taken us out of the 9th to the 16th in any event. Secondly, the practicalities of closing the mine. And thirdly, and most importantly, the implications of closing the mine and the extent of the problems that would have been created. So he deals with it at two levels. The first is the need for essential services to be maintained, and the second, the financial aspect. And in relation to essential services being maintained, he points to fundamental aspects such as water pumping, ventilation, cage taking people up and down, more significantly the methane build-up, and the fact that electricity was still running. But there were real dangers of not only substantial damage, but aspects such as flooding, aspects such as explosion because of the methane buildup, and water pumping, which would have had to be considered if you were simply going to close down the mine. And what he testified to, and he was not challenged on that, was that if you were to take each aspect, if you were to take essential services, if you were to take the concentrators next to the shaft, if you were to deal with the smelters that are a fundamental part of the operation, and the base metal refinery, and the number of people who would have to go to work in order to ensure those essential services were maintained, then the prospect of closing the mine down at that point in time was not only impractical but impossible in that time period. Impossible without creating substantial environmental concerns in relation to water pumping, concerns such as explosions because of the methane buildup. So it simply was not possible. He spoke in addition to the financial implications of closure, and again, that aspect was not challenged. So the first part of closure of the mine and the fact that some people would have had to work was dealt with by him in a manner which was not challenged. The second part is, if you were in those circumstances in response to the growing conduct on the part of those who were on strike, to close the mine, you're simply sending out a message for the future that the more unruly the behavior becomes, the greater the onus is placed on the employer in order to close down its operations. The final aspect was the criticism for Lonman having put out the message encouraging people to go to work. Now, there are two aspects that two submissions I want to make in that regard. The first is that it has to be implied in that criticism that Lonman ought to have kept quiet, and therefore by its silence discouraged people from going to work. Of course, that's the same as closure. That's the same as saying you ought to have closed. The second aspect to that, in relation to the items that the Commission is investigating, is that there is absolutely no evidence that those who unfortunately were harmed, killed or injured, and I'm talking of people in the first few days, because they had heeded the call to go to work, or because they were on their way to work because they wanted to go to work, because NUM had encouraged them to go to work, or the like. So you again enter into a realm of speculation. But the fundamental point is, the flip side of that criticism is that Lonman ought to have closed its operations. And the evidence given on the impossibility of closing it and the impracticality and the dangers to closing were never challenged. Commissioners, I'm now at the end of what I wish to say. If there are any questions, I'm happy to deal with them. But those are my submissions. Before I give up the mic, may I just turn to my right to find out if there's anything else I need to deal with?
Yes, that sounds like a sensible proposal.
I've been given the all clear to put the mic off now.
Yes, you didn't ask your attorney when you asked your leader. Right. Yes, thank you, Mr. Berger and Mr. Bam, for the arguments on behalf of Lonman. Do we have who's going to speak on behalf of the Mabebe, Mabalani, and Langa families? Yes. Yes, Mr. Rampela. And we've also got the Bapa Bamukhali. Do they want to go first? Have you, Mr. Rampela, have you come to terms with your learned friends from Bapa Bamukhali as to who's going to speak first?
The reason why I would ask them to go first is because there are some of the issues that have been raised by Lonman, and in which I have to confer with my brother.
So you'd like the Bapa Bamukhali community
to go first,
representatives to speak first?
Thank you.
Yes, please. Please put your name on record, sir.
Thank you, sir. Commissioner, my name is Myron Durance. I'm from the Johannesburg Bar. I appear with my learned colleagues, Naidu and Budu. Mr. Commissioner,
I think it'd be helpful if you spelled your surname for the benefit of the transcribers.
D for Daniel, D-E-W-R-A-N-C-E.
Thank you. D-E-W-R-A-N-C-E. Durance. All right, please commence with your argument.
Thank you, Mr. Commissioner. Our argument will be very brief. Mr. Berger will be yet again accused of stealing thunder. Our written response relates to the preliminary report by Professor Whittaker, Forrester, where she invites comments on the contents of the report. Our arguments will basically primarily focus on the housing issue in Marikana. The presence of lawnmen, like with any other mine, invites migrants to the area for people to seek employment. There's no criticism against that because that's how Johannesburg started and that's how Kimberley started. The effect of the migrancy is that, and the report also states it clearly, that the land of the Bapo ba Mogale has been invaded illegally or occupied illegally. That is identified as Wonderkop, where in 2012 the majority of Molonman employees resided, as well as in Kaganeng. That's also consists of informal settlements. The preliminary report quite puts it clearly that the Lonman has failed in its social labor plans in the providing of housing since 2007. Lonman has provided some justification for not doing that. But our criticism is basically is directed at the government, because in terms of the Section 26 of the Constitution, there's a duty on government to provide housing and to ensure that there's progressive realization of the right to housing. The report suggests that there's been an interview with the local municipality, which, in terms of the housing laws, is the responsible organ of state for development of housing and development of townships. The director of infrastructure at Madibeng municipality suggests that there's not sufficient funding, as well as the suggestions also that the municipality in Rustenburg doesn't have sufficient funding to provide housing. The report creates a bleak scenario in the sense that there's no sufficient water, there's not sufficient roads, not sufficient health care, and all of that is indicative of, or normally associated with, poverty. Now, the report also suggests that associated with the socioeconomic problems, which I referred to also, there's an increase in drug problems, there's an increase against abuse against women and children, and the unemployment levels are hovering at 74% in the communities. In fact, in Segwenyane, the migrants outnumber the local Bapo ba Mogale by 20-1. So this is a recipe for disaster, and it appears to us that the local government has done very little. I wouldn't say nothing. Our written submission says nothing, but I would say very little, because there is indication that they've addressed some of the issues. They've done very little to address the problem. We would submit that, and we referred the Commission to, in our heads of argument, to the relevant case law in the Blue Moonlight case, that an excuse that there's not sufficient funding is not acceptable. There's a continuous duty on the municipality, on the government, to review its policies to ensure that there's progressive realization of socioeconomic rights, especially in the context of socioeconomic rights. It may be a bit unfair in criticizing the municipality for them they're not here. I don't think they've been given an opportunity to have a look at our written submissions as well as the report from Professor Whittaker, and therefore we in agreement with the South African Human Rights Commission and Mr. Berger that an additional inquiry on additional mechanism be set up to address all the issues, especially the issues of socioeconomic, the fulfillment of socioeconomic rights. In fact, the report suggests that a government agency or relevant government department will be established to address the issues raised in the report, and also the relevant replies made to this report. And that's basically, Commissioners, our participation and our submissions in this respect. If there's any other questions if there's any questions, we'll be glad to field them.
No, thank you. We have no questions. What you've said is very clear and easy to understand.
As it pleases.
So, Mpela, would you like us to take the tea adjournment now? Give you a chance to look at your notes.
Listen for me.
So I didn't hear you.
I say,
Very good.
I say I appreciate that
I see,
very
all right.
much.
Yes, yes, I see. Right. Yes, thank you very much. We will adopt that adjourned for 3:15. Yes, Mr. Gumbi, the Commission is you.
Sorry, Chairperson, but we just thought it may be a good idea to explain to the public and the press that Mr. Ramaphosa's representatives are not going to be addressing oral submissions because there have been a series of inquiries made to us as to why his representatives are not here now.
I understood Mr. Butland had been in contact with the attorneys, and I wasn't sure what the final position was. And I was asked by a member of the press what was happening, and I referred her to Mr. Butland. But is there now confirmation that Counsel for Mr. Ramaphosa will not be addressing the Commission? Mr. Butland?
Chair, that's correct. We have received a letter stating that they stand by their written submissions in their original heads of argument and in their reply, and there's nothing that they wish to add to that.
Thank you. Well, Mr. Justice, that deals with the problem that you raised. Yes. Sorry? Mr. Rampele.
Thank you, Chair. Thanks, Chair.
I don't know why I called upon you as Mr. Gumbi. Mr. Gumbi, of course, has addressed us earlier this morning and last week, and I don't know what day it is of the Commission, but I'm sorry. I'm not sure whether Mr. Gumbi's cross or you're cross is a mistake, but anyway, Mr. Rampele, the floor is yours until 4 o'clock.
I think I would not have any problems with that, but I think Mr. Gumbi would actually have serious problems. Chair, thank you. I represent Mr. Langa, Mr. Mabebe, and Mr. Mabelani.
I think you represent the estates or families of those persons.
The families, that is correct. The families of the deceased, Mabebe and others. Our representation, Chair, is going to basically start with looking at whether the police, by their conduct, created tension that led to the deaths of our clients, and whether, because of that conduct, the police, we can say, should be found liable. The second will be in relation to lawnmen. We will then shortly discuss the conduct by NUM and the concessions that were made by AMCU. As you would know, Chair, much of our case was made out, or at least that's what we think, in the cross-examination of the witnesses that were before the Commission. And this representation is to buttress these concessions that were made. We start with the duty of the police in terms of the Constitution, which says that the object of the police service is to prevent, combat, investigate crime, maintain public order, protect and secure the inhabitants of the Republic and their property, and to uphold and enforce the law. Now we look at the conduct of the police and whether this conduct actually is in line with the objects as set out in Section 205. And we say that it is common cause that on the 10th of August, there was this dissatisfaction and workers going to the LPD, and there was about 2,000 to 3,000 of them. And we believe that as a result of this conduct, the police then developed a contingency plan. That contingency plan, if we're not wrong, is Exhibit U. The contingency plan is the contingency plan of 10 August 2012. Now we contend that that plan is testimony to the realization by the police of the seriousness of the situation that they were dealing with. According to that plan, the risks that were perceived and are in writing in that plan are that there was probable damage to property, there were intimidations, there were persons flocking together. I don't understand seizure, but it also says one of the threats was seizure. The operational plan then has got operational orders that are attached to it. And in clause 3.2 of the plan, it says, the orders are that the POP will parade, JOC will be activated at 7 o'clock on 2012-08-10 and remain operational for the duration of the strike. And then it also goes on to say all incidents must be reported to the JOC on hourly basis. This plan in clause 3.2.5 says no personnel may report off duty without being given an instruction to withdraw. 3.2.4, no deviation from duty will be allowed without authority of the JOC. We know that this beautiful plan that actually realized the danger, that danger that was clearly foreseeable to people in that area, which included Langa, Mabebe, and Mabelane, and that this plan that was supposed to be executed to protect them, just there's no evidence that this plan was implemented. There were no reports on hourly basis. There was no report to the JOC, and the Commission has not been furnished with any such report. Now, it is clear, just from the plan that was appreciated by the police, that they appreciated the danger, they knew what to do, and they did not do what they knew was supposed to be done according to their constitutional duty. Now, the first recommendation here too is that the Commission must find that the police, in their omission to implement their own plan on the 10th or from the 10th of August 2012, created conditions that resulted in heightened tensions in Marikana. 2, the omission to implement the plan created lawlessness, where strikers were aware that they were not monitored, and this bolstered their courage, and they almost felt invincible. This weakened a late intervention that was tried to be mastered. The fourth was that this omission encouraged the marauding by angry strikers, free to harass, and as we have seen, shoot, injure, and in our case, killed our clients with no intervention of the police, because there was a plan. That plan was supposed to say, in this hour, this is what is happening, and that plan was not implemented. But this plan also says that the plan has to be implemented on a 24-hour basis. Again, a realization of the importance of the task at hand, that they could not let their eye off the ball. Yet, the police failed to execute this plan. And saying, if there's a duty on the police to protect, if the police are aware that that duty has to be activated by taking action, as in the case of Marikana, and then they go on further to actually put and draw up a plan with all the components that one needs for people to be secured and fail to then implement that plan. They have failed in that duty. But that the second recommendation we make here too is that the police must publicly publish information on what actually made them not to implement the plan. Who is responsible for omission of a situation that we can clearly call a constitutional challenge to our country, developed primarily by an omission which we cannot live without explanation. So this omission has to be explained. The third recommendation is that those that are found to have been derelict of their duties to implement this plan must be brought to book. Because as a result of this, we're talking about 44 lives. The second submission that we make is there is a duty to secure non-striking workers. And this duty, in relation to the 12th of August, actually was very clear, because there were multiple reports of attacks of people going to work. We've just heard, and this is uncontested, of people that were being attacked, and of some attacks that happened where people would ordinarily pass either to or from work. These people were not on strike. We have a constitution that says freedom of association must be promoted or must be protected. And in my heads, I have tried to show that the freedom of association that has to be protected includes the freedom of choice not to go on strike. And that is the right that the police have a duty to protect. So, what we have is, we have that on the 12th of August, in the morning at 7, there was a nyala and a kombi of policemen that was around the area where the strikers were busy with their rituals. We do not know who was in this nyala. We do not know what instruction these people that were in the nyala were given. We do not know why they withdrew from that when we have evidence of Lieutenant Colonel Fusser clearly indicating that on the 12th in the morning they had received reports of people having been injured the previous day, of shootings that were reported to the police. Now, here you have a police kombi with persons inside and a nyala. They appreciate a situation developing that may result in the loss of life. They don't call backup if they feel that they are outnumbered. They don't give an indication of what dangers are there. And they withdraw. Because they were there at 7, it might happen that just an hour or so after the withdrawal, Mabelane and Fundi and the others were put in a situation where Mabelane was then killed. And we're saying that withdrawal, without an explanation, and I suppose the President correctly says, public, nationally and internationally, have concerns about are we, as South Africans would be saying, are we safe? Would the police actually be spectating our demise? And in this particular instance, we would be asking, would they be withdrawing in the same manner that they withdrew when the Nyala and the Kombi withdrew on the 12th, leaving the security of Lonmin to deal with a situation that they actually are completely not trained to deal with? Is that now upholding Section 205 of the Constitution? Is that upholding the right to life? And they say, in this particular situation, the police just failed to do their duty.
Assuming you are correct in asserting that there was a breach of duty by the members of SABC, is there evidence on which a finding can be based that there was a causal connection between that breach and the death of Mrs. Mabebe, Mabelani, and Langa? Now, presumably each of those has got to be dealt with separately, because the circumstances of the deaths were different. But what evidence, you don't address this in your heads, what evidence is there of a causal connection between the breach of which you complain by members of SABC and the deaths of the three persons in respect of whose estate, on behalf of whose estates, families, you appear before us?
And stop them from doing their duty.
How big is the property that had to be patrolled?
No,
the evidence, the area over which contains the mines, the Lonmin mines, how big is that area? What is the area that would have to be patrolled? The combi that you are talking about, the Nyala, they obviously can't be all over the property all the time.
That is.
So the mere fact that they were withdrawn doesn't in itself lead ineluctably to the conclusion, on the balance of probabilities, that if they had still been there, this is what Mr. Berger calls the counterfactual. If they had been there, is there a basis for saying that the deaths wouldn't have occurred? In other words, as I put it to you earlier, what evidence is there of a causal connection between the breach of which you complain and the deaths of these three gentlemen?
Okay. I want to believe that there was only, and there is no evidence that the persons that they were spectating doing their rituals were more than one group. There is no evidence that it was another group that attacked Mabelani. If the threat came from that group, there was no need for them to be anywhere else but where these people are. And that is the evidence that we have, that the strikers went through a ritual, and then they started moving, and in that movement, they met with Foster, they met with Lowe, they attacked a Cohen Security armored vehicle, and then Mabelani. So
sorry to interrupt you.
Yes.
I put you, the facts in respect of each of the three deaths differ. And it may be that it's easier to find a causal connection between the breach of which you complain, if it's established, and the deaths of Mr. Mabelani and Mr. Fundi than it is in the case of the other two deceased persons that above whose families you're appearing, namely Mr. Mabebe and Mr. Langa. The area around the hostel, the area around the NUM office, the area where the activities took place in relation to the death of Mr. Mabelani and Mr. Fundi, that may well have been a focal point which should perhaps have been patrolled with a fair degree of regularity. But what about Mr. Langa and what about Mr. Mabebe? Anyway, I'm putting the question to you because I'd like to hear your answer.
See, the plan clearly indicated the area that was supposed to be covered. Clause 1.2 of the plan says the area where the operation is to take place, namely Western Platinum Mine, Kari Mine, and Eastern Platinum Mine, which falls within the policing precinct Marikana SAPS. And there is no evidence that these areas that you are referring to do not fall within this venue. So in their plan, they made a plan that covers the eastern part, or the eastern and the western platinum mine. And therefore, an argument that may come, which I think will be a fair argument, that we could not be there. The question would then come, but in your plan, that is the area that you cover. So you had to be there, or your plan was then supposed to say, because of our capacity, we can only cover east and not west. So there is a causal connection between the omission to cover the area that is in the plan when it comes to Mabebe. When it comes to Langa, it will be a slightly complex matter. And there I would have difficulty because they were not in the venue that is put forward in the contingency plan. Thank you, Chair. May I then go forward, Chair? Thanks. But I also, in my submission, will say that it is not necessary in this situation for the police to have known Mabelane or Mabebe. If they fell within the area of operation, then those, at least there must be evidence before the Commission that attempts were made and those attempts failed, and those attempts were in line with a feasible plan that was prepared by the police. But I also want to venture to respond to a further question that you asked. What about Langa? Now, assuming that there was no plan, but there is knowledge by the police that the workers of Lonmin are probably or possibly going to be facing intimidation or even be killed on their way to work. The Constitution, and in the interpretation of our Constitution, we say that this right to life is a right that we cannot denigrate or derogate.
Sorry,
The
Mr.
Constitution...
Rampel. Sorry, Mr. Rampel. I suppose this complaint of this failure of the police to implement the contingency plan, you covered in cross-examination. In other words, you gave them an opportunity to explain why. Did you?
Yes, I did.
What was the explanation?
There was no explanation. There was no explanation given. I asked one of the police officers that are involved in the training of the police whether in their training they are aware that a plan that is properly developed can just be omitted and not be carried out. And there was no clear explanation before the Commission on how.
Haven't you got a stronger point than that? The captain, I think he's a major, Major Govinder was listed in the plan as being someone who's playing a very important role. And his evidence was he was never even told about the plan, never told he was mentioned in the plan, never told what he was supposed to do. So the failure to implement the plan is illustrated not only by the evidence that you dealt with in cross-examination with other witnesses, but Major Govinder's own evidence is very strongly in your favour as far as that's concerned.
Is it in agreement with me that there was an omission? How that omission took place was not put before the commission? Because that is that
What I'm
is
saying to you is the evidence in relation to the plan and the non-implementation of the plan. An important item of that evidence relates to the evidence of Major Govinder, who was listed in the plan as someone who would be responsible for visible policing. And according to his evidence, he was never even told about the plan, not told about the role he was supposed to play. That's the point in your favour.
Thank you, Chair. I always appreciate your assistance. So what we submit as a recommendation is that, in the same manner that we've stated, that there has to be full disclosure by the police on what actually happened for them to actually not take their responsibility in the manner in which they themselves had indicated they were prepared to do. But I also would like to bring to the attention of the Commission one of the statements. I think it was a statement that was submitted by Senior Counsel Tip in one of the bundles that he submitted. Unfortunately, Chair, you will excuse me with the issue of the exhibits. But in that bundle that was submitted, there is a statement by one of the loanman officials called Mr. Ranto. I think it's Lucas Ranto. Now, part of that statement has got very concerning actually facts. And that is, Mr. Ranto realized that loanman security would not be able to deal with the strikers. He actually says, I then called Mr. Govinder and asked Mr. Govinder for support to say, we will not be able to deal with this situation. You have more than 1,000 strikers. And in his statement, he says, Mr. Govinder was disgruntled. He showed disgruntlement at this. There was no clear indication whether they would get the support they needed. He called Lieutenant Colonel Merafi, and he says, Lieutenant Colonel Merafi was sarcastic. That is how he describes the response that he got. And this sarcasm and disgruntlement, if one reads the statement, comes from the manner in which he perceived the local police station was treated. And he said, well, why, I think something was said like, why don't you go to the province so that, because we always receive instructions from the province when it comes to you. Now, this statement clearly indicates that there was an issue with the local police station. And maybe, and it is something that, again, it would be good if, and we recommend that the police be permitted to make a full account of why the absence on the 11th and the 12th, because
when Major Govinder gave his evidence, you didn't question him about it, did you? I say, when Major Govinder came and gave evidence, you didn't question him about this point, did you?
Well, I do not think that, Chair, we're in a court of law where if you have that a witness is not questioned, therefore the matter must rest. When there's a clear omission especially on the side of the state. You see, Chair, well, obviously I wouldn't be having that authority here, but there is authority on commissions that if there's a submission, especially against an obligation by the state, it would be cumbersome for the commission to expect the complainant or the cross-examiner to have followed the procedures that one would follow in a court of law. So the fact that he was not questioned should not be reason for the commission to say there is no evidence that there was contestation about this. There is still an obligation in terms of the Constitution, and the public needs to know, because Ranto clearly demonstrated a response of disgruntlement, and clearly Merafi was not prepared to do as you would normally do because of the situation. The public should know, are the internal fracases of the SAPS going to compromise the right to lives of the public? And that, we recommend, is something that the Commission must put to the SAPS, because beyond this Commission, it is in our interest to know that the Constitution and its values are actually protected by the police.
I understand. I see you've got 10 minutes left. You haven't touched the part of your heads in relation to the liability of Lonman. Are you just going to take those as read? It's quite a full written argument on that, but
yes,
you haven't mentioned it at all in your oral address. Anyway, you've got 10 minutes left.
Well, I think we didn't start at 4:15, Chair. We took a bit of time. I think about 5 to 6 minutes were eaten from my time by the break.
Given
45 minutes.
And you started at 20 past, I'll
Yes.
give you another 10 minutes tomorrow morning. That means, in other words, you can carry on now to 4.
Okay, thank you,
10
Chair.
minutes tomorrow morning.
Thank you, Chair.
That's
But I think I'll do the 10 minutes. Let's see. So, our submission, Chair, is that there was a duty on the part of the police to protect that area. Actually, in my head, I go on to say that the state, where there's a possibility of life of citizens being threatened, must investigate, take measures to protect. And in this case, the life that was threatened was located at Marikana. It was directed at non-strikers or at those persons that would be in confrontation with the strikers. So the target was clearly identifiable. The area was clearly identifiable. Not only do you have that, you have a police act that was amended to say, and if a crime needs national response, then we have someone who is going to make sure that there is national response on the crime. Now, from the 10th for the duration, I don't think that this was given that type of attention. And I want to submit that even longer, because of even international best practice, which says that they must investigate if there's a possibility of a threat to life of a citizen. They must have looked at the villages and the workers in those villages and how they would be protected in this instance, because it was clear that they were targets. Let me go to Lonmin. And, well, before I finish, one of the recommendations, Chair, is that, and I know that you don't make absolute decisions, but the issue of damages, that it would be, maybe fair is not the right word, but you would understand what I mean. It would be useful if the Commission were to make a finding on the liability of the police in relation to this. And further, if there's an issue of, say, amount or quantum, then it could be directed to a further body. Because I believe that having to expect that these poor families should go through another process of trying to prove what we've been trying to prove in the last 2 years in this commission would be cumbersome on them. I'll go to Lonmin. And in relation to Lonmin, it's interesting because very interesting propositions were made by Lonmin. Maybe I should start with the first.